All right, going live, reading about confidentiality from professional responsibility. Um, Happen to, let's just the regular general rule out. A lawyer must not reveal any information relating to the representation of a client unless the client's consent or some other exception applies. The rationale is to maximize trust and therefore candor, allowing the adversarial system to work. Additionally, the lawyer is generally prohibited from using confidential information that is not generally known to the client's disadvantage unless the client consents or an exception applies. As part of the duty of confidentiality, a lawyer also has an affirmative duty to take reasonable measures, for example, electronic security measures, to prevent unauthorized access to or inadvertent disclosure of a client's confidential information. 3.1.1 broad scope. The duty of confidentiality applies regardless of whether the client requested it be kept confidential or whether its revelation might harm or embarrass the client. It applies regardless of the source of the information and prevents all types of disclosure, telling a friend, telling opposing counsel, testifying in court about it, and so on. 3.1.2 timing. The duty of confidentiality applies to information gained during consultations with prospective clients, even if the lawyer isn't hired. For discussions of how this may result in conflicts of interest, see section 5.3. Additionally, it continues to apply even after the client relationship is terminated and even after the death of the client. 3.2 exceptions to duty of confidentiality. Where an exception applies, the lawyer may disclose a client's confidential information only to the extent reasonably necessary to meet each exception. Also keep in mind that these exceptions permit but do not require the lawyer to disclose the confidential information, consent, or implied authority. A lawyer may reveal information relating to the representation of a client if the client gives informed consent or if the disclosure is impliedly authorized in order to carry out the representation. For example, a lawyer may share a client's information with other members of their firm and with outside contractors working on the client's matter. Then there's a hypo. Talking about, can you tell the U.S. Patent Office about a patent that your clients hired you to file? Yes. Prevent death or substantial bodily harm. A lawyer may reveal information to prevent reasonably certain death or substantial bodily harm. California difference. The California counterpart exception is similar, but the disclosure must be to prevent a criminal act that is likely to result in death or substantial bodily harm. Before disclosure, the lawyer must, if reasonable under the circumstances, make a good faith effort to persuade the client not to commit or continue the criminal act if it is the client who will be committing the crime, or to pursue a course of conduct that will prevent the crime. The lawyer must also inform the client of the lawyer's ability to decision to reveal the information or decision to reveal the information. So in California, everything's the same except a disclosure may be made to prevent a criminal act that is likely to result in death rather than just information to prevent death. So anyway, did I miss something? No. This is the only formal exception included in the California rules. However, the California rules recognize that other exceptions exist under California law. 3.2.3, prevent or rectify substantial financial loss. A lawyer may disclose confidential information to prevent a client from committing a crime or fraud that is reasonably certain to cause substantial financial loss to a person if the client is using or has used the lawyer's services in furtherance of a crime or fraud. Disclosure is to allow to rectify or mitigate the financial loss if the crime is already completed. California difference. California does not recognize the financial loss exception. 3.2.4, defend self or establish claim against client. Suppose a client sues a lawyer for malpractice, brings disciplinary actions against the lawyer, and refuses to pay the lawyer, forcing the lawyer to sue the client for their fees. The lawyer may disclose confidential information about the client's matter in these proceedings to defend themselves or establish their claim. Keep in mind that there must be an actual claim or proceeding involved. For example, suppose a client posts a bad review of a lawyer on the internet, the lawyer wouldn't be able to defend themselves under the exception by disclosing confidential information about the client's matter in their public response. 3.2.5, obtain legal ethics advice. A lawyer may disclose confidential information to obtain confidential legal advice about the lawyer's personal duty to comply with legal ethics rules. California difference is this isn't a recognized exception. 3.2.6, address conflict resulting from organizational change. Address a conflict from an organizational change. A lawyer may reveal information to detect and resolve conflicts of interest arising from their change of employment or from changes in the law firm's composition or ownership, for example, a merger or purchase of a law practice. However, the lawyer must not reveal information that will compromise the attorney-client privilege or otherwise prejudice the client. Note that routine conflict checks within a firm would fall under the impliedly authorized exception above. California difference is there is no such exception for addressing a conflict from an organizational change. 3.2.7, another exception is to a federal exception or nationwide ABA model rules of professional conduct. Exception is to comply with a court order or law. The lawyer is permitted to comply with a court order or other law requiring a lawyer to disclose information about a client. However, the lawyer should first try to challenge the court order requiring disclosure and seek appellate review if there are grounds to do so. Additionally, another ethics rule may permit or require the disclosure of confidential information, specifically outside reporting of corporate violations. And candor to the tribunal are the two rules that supersede confidentiality, which are, again, corporate violations and candor to the tribunal. The California difference, in California courts have recognized the exception for complying with a court order or law. However, note, however, that other ethics rules generally do not supersede the duty of confidentiality in California. 3.3, recap of attorney-client privilege. As your evidence materials discuss, the attorney-client privilege allows the client to refuse to testify and prevent their lawyer from testifying before a court or other government tribunal about confidential communications between them and their respective agents. The privilege applies only to communications that pertain to legal services. For example, communications relating to business or personal advice wouldn't be covered for purposes of the privilege. A client is a person or entity seeking legal services from a lawyer, and the privilege applies only to communications that pertain to legal services. When the client is a corporation, communications with a corporate employee are generally privileged if they are directed at or authorized by the corporation and concern the employee's duties. Like the duty of confidentiality, the attorney-client privilege attaches to consultations with prospective clients and continues after the representation ends. The difference in California is that the attorney-client privilege terminates after the client's death when the client's estate is settled and the personal representative is discharged. Distinguish, so Part A under this attorney-client privilege section is distinguishing attorney-client privilege from confidentiality. It's much narrower than the duty of confidentiality. The key differences are as follows. The attorney-client privilege is an exclusionary rule of evidence law. It prevents the lawyer or client from being compelled to testify about the privileged communications. In contrast, the duty of confidentiality is an ethical rule that prevents all types of disclosure, both inside and outside the courtroom. The attorney-client privilege only covers confidential communications between the lawyer and the client and their agents. In contrast, the duty of confidentiality covers all types of information relating to the representation from any source. Main exceptions: the attorney-client privilege doesn't apply where the client seeks the attorney's services to enable or aid anyone to commit a future crime or fraud, to a communication that is relevant to an issue of breach by either the lawyer or the client of the duties arising out of the attorney-client relationship, or where the client otherwise puts the legal services at issue in the case. The civil litigation between multiple persons who were formerly the joint clients of the lawyer, and in certain situations where the lawyer is called to give evidence about the competency or intention of a client who has attempted to dispose of property by will or inter vivos transfer. Those are the main exceptions where the attorney-client privilege doesn't apply. The difference in California provides an additional exception when disclosure is necessary to prevent a criminal act that the lawyer reasonably believes is likely to result in a person's substantial bodily injury or death. As we have learned, this is also an exception to the ethical duty of confidentiality in California. So the next big subsection in professional responsibility is Part 4, duty of loyalty and conflicts of interest, introduction and conflicts with current clients. 4.1, introduction to clients of conflicts of interest. A lawyer owes a duty to their client and must avoid or properly address any conflicts of interest. Consequences: some conflicts are completely non-consensual, meaning getting a waiver from a client won't solve the problem. Other conflicts can be resolved with consent from the client and or meeting other conditions. A lawyer's failure to handle a conflict properly can have the following unpleasant consequences: disqualification as counsel in a litigated matter, professional discipline, and civil liability for legal malpractice. Section 4.1.2, imputation. Generally, when a lawyer can't take on a matter because of a conflict of interest, the other lawyers in the firm are also barred from taking on the matter. The conflict is said to be imputed from the first lawyer to the other lawyers. For purposes of this rule, a firm means any group of lawyers who practice closely together, such as in a corporate law department, legal aid office, or prosecutors or public defender's office. The exceptions to imputed disqualification are as follows: when a conflict is uniquely personal to the disqualified lawyer and would not materially limit the representation of the client by the other lawyers in the firm. When the conflict is based on certain situations involving the disqualified lawyer's prior work or employment, and the lawyer is properly screened from the matter and the affected persons are given notice. These situations will be discussed in the next module. Also note that an imputation can be waived by the affected clients. On the exam, if there is more than one lawyer in the facts, check for shared conflicts. 4.2, general. Let's see what's going on inside real quick. When conflicts exist, direct adversity or material limitation. These are under the general types of conflicts with current clients. 4.2.1, when conflict exists, direct adversity or material limitation. As a general rule, a lawyer must not represent a client in either of the following situations, which are both discussed in further detail below. The client will be directly adverse to another client in either of the following situations, which are both discussed in further detail below. The client will be whether in the same or a separate matter, I meant to say, or there's a significant risk that the representation of the client will be materially limited by the lawyer's own interests or by the lawyer's responsibilities to another client or former client or third person. These conflicts are frequently tested, so you should do your best to memorize the rules that are covered in this section. Steps for resolving a current client conflict. If there is a conflict as described above, the lawyer may still undertake the representation if the following 4 conditions are satisfied. The lawyer reasonably believes that they can competently and diligently represent the client despite the conflict. This is an objective, reasonably prudent, and competent lawyer standard. The representation is not prohibited by law. The representation does not involve asserting a claim by one client against another client represented by that lawyer in the same proceeding before a tribunal. This form of direct adversity, where the lawyer is on both sides of the same litigation, is always not consentable. Each affected client gives informed consent confirmed in writing. Remember that consent must be informed. This means that the affected client must be aware of all the relevant circumstances, reasonable alternatives, and foreseeable ways the conflict might harm them. Sometimes the lawyer's duty to confidentiality to a current or former client prevents them from disclosing information that the other client needs in order to understand the conflict of interest. In that situation, the conflict can't be waived. California difference. Recall that the California rule is the same, except that it requires informed written consent, meaning that both the disclosure to the client and the consent from the client must be in writing. 4.2.2 Direct adversity conflicts. A lawyer generally must not represent a client who is directly adverse to a different current client unless the conflict can be and is properly waived by the affected clients as described above. There is a direct adversity conflict even if the lawyer represents the clients in totally unrelated matters. The main examples of direct adversity are the lawyer represents multiple clients in the same matter, and their interests are in actual conflict, for example, as opposite sides in a transaction or in litigation, or when one party wants to file a claim against a co-party. Even if co-parties' interests are generally aligned to begin with, relationships can sour during the matter and direct adversity can develop. A lawyer accepts representation of a client who is an adverse party in a different matter the lawyer or firm is handling for an existing client. That's another example. Or a lawyer accepts representation of a client in a matter adverse to an existing client of the lawyer or firm. And last, as part of representing a client, a lawyer must conduct a harmful or embarrassing cross-examination of another existing client of the lawyer or firm. Keep in mind that mere economic adversity does not amount to direct adversity for conflict purposes. A lawyer or firm can simultaneously represent 2 clients who are competitors, provided the clients are not adverse to each other in any of the matters. There's some hypos I'm skipping through. California note. Under California law, a lawyer who is retained by an insurance company to represent the insured also represents the insured company for conflicts purposes. Thus, the lawyer must not file a direct action against that same insurer in an unrelated case without the insurer's consent. However, by statute, the lawyer has no duty of loyalty to the insurer when the insurer's interest in each matter is only as an indemnity provider and not as a direct party to the action. And the hypo here might be helpful. Insurance company retained you to represent driver 1 in a tort case. May you now represent driver 2 in a different case against driver 3 and insurance company, the same insurance company. Driver 3's insurer for when one of those is limited to indemnity. The answer is yes, I think. It doesn't actually say here. But since there's a limited amount of insurance companies, that's why that law exists. So you can't be limited to doing 3 tort actions and you're done. 4.2.3 Material limitation conflicts. As discussed above, when Even where direct adversity doesn't exist, a lawyer generally must not represent a client if there is significant risk that the representation of the client will be materially limited by the lawyer's own interest or by the lawyer's responsibilities to another client, a former client, or third person, unless the conflict is properly weighed by the affected clients as discussed above. The significant risk of material limitation conflict rule is relevant in any situation where the lawyer's ability to represent a client could be affected. Common examples include where a lawyer is representing multiple parties on the same matter and the parties have potentially conflicting interests. For example, a company and a employee in an immigration matter, or spouses in preparing wills and trusts. Note that while this conflict may be consentable in civil cases, the rules caution against representing co-defendants in a criminal case because of the high likelihood that their interests will diverge. Skipping on, in an essay, when the lawyer is representing multiple clients in a matter, it's always a good idea to discuss the risks to confidentiality. Another example is where a lawyer is dealing with a former client conflict that could affect the representation of the current client. We'll discuss some former client conflicts later. Another example is when the client owes a duty to some third person and it would affect their handling of the matter. For example, when serving on the board of directors of a corporation. There's going to be several hypos here. Okay, well, there's one, and then there's another example where the lawyer has any personal or financial interest relating to the matter. The ABA rules specifically note that close family relations with opposing counsel constitute such a conflict and require consent. California disclosure requirements for certain relationships. The California rules contain additional provisions regarding a lawyer's relationships with parties, witnesses, and attorneys involved in the client's matter, even when a significant risk of material limitation is not presented. The following relationships always require written disclosure of the client, where the lawyer or another lawyer in their firm has a legal, business, financial, professional, or personal relationship with or responsibility to a party or witness in the client's matter, where the lawyer or another lawyer in the firm is an immediate family member of or lives with or is in an intimate personal relationship with or is a client of the firm of another party's attorney in the client's matter. If the relationship does not create a significant risk of material limitation, the usual informed written consent from the client is required. Specific types of conflicts with current clients. We just covered the general rules for conflicts of interest that involve current clients. However, there are some kinds of conflicts that arise time and time again in law practice. They are so common that there are specific rules to deal with them. Some of these conflicts can be resolved if certain conditions are met, but others are non-consentable. 4.3.1, business transactions with the client and pecuniary interests adverse to the client. A lawyer must not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or money interest that is adverse to the client unless all of the following conditions are satisfied. The terms are fair to the client. So the the mnemonic is first have coffee. I think something like that. So first, and then the terms and lawyer's role in the transaction are fully disclosed to the client in a writing that the client can reasonably understand. The client is advised in writing that they should get outside independent advice from an outside lawyer before entering into the arrangement, and the client gives informed consent in a writing signed by the client. So I think it's first do, oh man, I have to look it up. First, discuss over coffee. So fair disclosure, outside counsel, and consent. That's the acronym. First discuss over coffee. You remember the acronym. So the terms must be fair. The client, the terms and the lawyer's role in the transaction are fully disclosed to the client in a writing that the client can reasonably understand. The client is advised in writing they should get independent advice from an outside lawyer before entering into the arrangement, and the client gives informed consent in a writing signed by the client. So, first discuss over coffee. Fair disclosure, outside counsel, consent is the mnemonic. My God. Of course it's written here, so I have to look it up. There's some hypotheticals. Common examples of business transactions with clients accepting non-monetary property such as stock as payment for legal services, borrowing money from a client, or purchasing property from a client, selling property to a client, taking an interest in a client's property as security for payment of fees. Standard commercial transactions. Note that this rule does not apply to standard commercial transactions between the lawyer and client for products or services the client generally markets to others. For example, if the client is a bank, the lawyer can open a checking account at the bank. Professional responsibility. Okay. 4.3.2, misuse of client's confidential information. As we've discussed in the confidentiality and privilege module, the lawyer must not use confidential information to the client's disadvantage unless the client gives informed consent at some exception to the duty of confidentiality applies. A lawyer is similarly prohibited from using confidential information against former and prospective clients unless the information has become generally known. 4.3.3, substantial gifts from clients must not solicit gift or prepare instrument. A lawyer must not do either of the following: solicit a substantial gift from a client for the lawyer or the lawyer's relative, prepare an instrument on behalf of the client, giving a substantial gift to the lawyer for the lawyer's relative. However, these prohibitions do not apply if the client is related to the recipient of the gift, that is, the lawyer or the lawyer's relative. California difference. The California rule is the same with respect to soliciting gifts, but is somewhat more flexible regarding the preparation of instruments. It provides that a lawyer may prepare an instrument that creates a substantial gift for the lawyer or the lawyer's relative, even where the client isn't related to the recipient, if the client has been advised by an independent lawyer who has provided a certificate of independent review. Financial assistance to client. A lawyer must not provide financial assistance to the client in connection with pending or contemplated litigation with the following exceptions. A lawyer may advance court costs and litigation expenses, and the repayment may be contingent on the outcome of the case, meaning the lawyer and client can properly agree that the client only needs to pay the lawyer back if the client wins. If the client is indigent, the lawyer may pay the court costs and the litigation expenses outright. A lawyer representing an indigent client pro bono may provide modest gifts to the client for food, rent, transportation, medicine, and other basic living expenses. However, the lawyer must not promise or imply the availability of such gifts, seek to accept reimbursement from the client or anyone affiliated with the client, or publicize or advertise a willingness to provide such gifts to prospective clients. California differences. The California rule applies to financial assistance to a client in all contexts, not just litigation. It is more detailed than the ABA rule and adds the following. It permits the same activities as the ABA rule regarding advances to clients, paying expenses of indigent clients, not just litigation expenses, but any expenses incurred in promoting or protecting clients' interests. It prohibits a lawyer from buying a potential client with a promise to pay the potential client's debts. It does not contain the ABA provision for pro bono representations. However, it provides that after the lawyer is hired, they may lend the client money for any purpose if the client gives them a written promise to repay the loan. It specifies the client's consent. With the client's consent, the lawyer may pay or agree to pay the client's expenses to a third party from funds collected for the client as a result of the representation. And 4.3.5, aggregate settlement agreements. The lawyer must not participate in the making of an aggregate settlement agreement, meaning an agreement where multiple parties settle their claim at the same time unless the lawyer discloses to each client the existence of the nature of all claims and pleas involved in the participation of each person in the settlement. And 2, each client gives informed consent to the agreement in a writing signed by the client. Transparency is key here. Even under the ABA rules, business transactions and aggregate settlements require the client's signature. 4.3.6, compensation from someone other than the client. A lawyer must not accept compensation for representing a client from someone other than the client unless the client gives informed consent and there is no interference with the lawyer's independence of professional judgment or with the lawyer-client relationship. And 3, confidential information relating to the representation of the client is... Bless you. I think I went too far. Did I go too far? Okay, so it doesn't interfere with the lawyer's independence of professional judgment. Okay, so 1, the client gives informed consent to compensation of attorney fees from someone other than the client. There's no interference with the lawyer's independence of professional judgment or with the lawyer's lawyer-client relationship, and confidential information relating to the representation is not protected. California differences. While the ABA rule requires only informed consent, which may be oral, the California rule requires the standard informed written consent. The California rule also provides that disclosure and consent are not required at all if 1, non-disclosure or the compensation is otherwise authorized by court order. Or 2, the lawyer is rendering legal services on behalf of a public agency or nonprofit organization. That provides legal services to the public. And the rule also notes that in emergency situations, the lawyer can obtain the client's consent after the fact. 4.3.7, settling existing malpractice claim with unrepresented client or former client. A lawyer must not settle a claim or potential claim for malpractice liability with an unrepresented client or former client without 1, advising that person in writing that independent counsel is desirable, and 2, giving that person a reasonable chance to consult with independent counsel. 4.3.8, 4.3.8, prospectively limiting liability for malpractice. A lawyer must not make an agreement prospectively limiting the lawyer's ability to a client for malpractice unless the client is independently represented in making that agreement. California difference: the California rule does not allow a lawyer to prospectively limit malpractice liability to a client in any circumstance. Whereas in the ABA model rules, that's fine as long as you encourage the client to go seek outside counsel and you give them time to do so. I think that's what that first paragraph just said. 4.3.9, acquiring literary or media rights concerning a client's case. A lawyer must not acquire literacy or media rights to a story based on, in substantial part, on information relating to the lawyer's current representation of the client. However, the lawyer may acquire such rights after a client's legal matter is entirely completed, appeals and all. The California difference: California did not adopt this rule. A lawyer's acquisition of literary or media rights based on the client's case is treated as business transaction pecuniary interest adverse to the client, and must meet the requirements of the rule. Skipping the hypo. Do we get to a new section? We don't really get to a new section, so I'm just going to stop at the end of page 35. Check on Bubba. Acquiring proprietary interest in litigation. A lawyer must not acquire proprietary interest in the cause of action or subject matter litigation the lawyer is conducting for a client, except that the lawyer may, 1, acquire a lien authorized by law to secure the lawyer's fee or expenses, and 2, contract with the client for a reasonable contingent fee in a civil case. This rule is limited to litigation matters. For example, a patent lawyer can represent a client in a patent application and accept an ownership interest in the patent as payment for the legal services in compliance with the rule for business transactions with the client discussed in 4.3.1 above. However, if the lawyer is representing the client in a lawsuit involving the patent, the lawyer would not be able to accept the ownership interest. The rationale for this rule is that we don't want the lawyer to have too much of a stake in the outcome because this could affect their professional judgment. California difference: California did not adopt this rule. The lawyer's acquisition of the ownership interest in the subject of the representation is treated as a business transaction pecuniary interest adverse to a client and should be analyzed under that rule. So, the next thing is talking about foreclosure on page 36, midway through. Okay, there's only one more page, so I'm going to get to the end of this. Participation in foreclosure or sale must comply with probate code. This is California only. In connection with probate, foreclosure, receivers, trustees, or judicial sale, the California rules provide that a lawyer must not do either of the following: directly or indirectly purchase property in an action or proceeding in which such lawyer or any other lawyer with whom the lawyer is personally and professionally affiliated is acting as a lawyer for a party or as executor, receiver, trustee, administrator, guardian, or conservator, represent the seller in an action or proceeding in which the purchaser is a spouse or relative of the lawyer or another lawyer in the firm or an employee of the lawyer. However, this rule does not prohibit a lawyer from participating in transactions that are authorized by and comply with the probate code. There is no APA counterpart to this rule. Sexual relationships with clients. A lawyer must not have a sexual relationship with a client, even if the client consents and even if representation won't be affected, unless the sexual relationship predates the lawyer-client relationship. If the client is an organization, the rule applies to a sexual relationship with the constituent of the organization who supervises the lawyer's work or consults the lawyer about the organization's legal matters. California difference: California rule is the same, but includes an additional exception for when the lawyer and client are married or in a registered domestic partnership. No imputation. All other specific conflicts discussed above are imputed to other lawyers in the disqualified lawyer's firm. However, a conflict created by a sexual relationship is personal in nature, and unlike most conflicts, it is not imputed to the lawyer's colleagues. Pre-existing relationship may still cause conflict. Even where the sexual relationship predated the lawyer-client relationship, the lawyer should consider whether the sexual relationship will materially limit the lawyer-client relationship and implicate the general conflict of interest rule for current clients. And then so on page 38, we stop and we're talking about the duty of loyalty and conflicts of interest for lawyers' former work and special roles.